Hello, my name is Donna Newman and I am a partner in the Finance Litigation Group at Stephenson Harwood. Welcome to the fourth in our Autumn 2018 series of 4 short webcasts in which we take a bite-sized look at some key topics that have emerged from court or regulatory decisions over the last year. In today's webcast, Ellen Gallagher, an associate in our Regulatory Litigation Group, will take a look at the themes emerging from the FCA's enforcement action over the course of 2017 and 2018, and will consider what the FCA's priorities are likely to be for the coming year.
In this webcast, we're going to take a look at the trends emerging from FCA enforcement action against firms and individuals over the last year, and look forward to consider what the regulator's priorities are likely to be for the year ahead. We'll be drawing on the FCA's annual enforcement performance report and anti-money laundering report for 2017-18, and also the FCA's business plan for the coming year. The report set out that the FCA is currently investigating 75 firms for AML issues, using both its civil and criminal powers under the money laundering regulations. As well as evidencing its continued focus on financial crime, the FCA attributes the recent increase in the number of AML investigations to the changes in its overall approach to opening investigations earlier, as part of the policy changes introduced in early 2017 in response to recommendations made in Andrew Green QC's 2015 report into the FCA's enforcement actions following the collapse of HBOS. On the supervisory side, the information provided to the FCA by firms in the Financial Crime Data Return, introduced in 2016, is now being used as part of the FCA's AML risk assessment processes. This includes the selection of firms for proactive inspection, focusing on those with higher inherent money laundering risks, due to, for example, their customer base and the jurisdictions in which they operate. The FCA's focus on these factors has tended to lead to overseas branches of foreign banks being particularly likely to come under the spotlight, and we expect this trend to continue. Following the introduction of the Money Laundering, Terrorist Financing and Transfer of Funds Regulations 2017, or MLRs, the FCA published guidance on how firms subject to the regulations should treat politically exposed persons, or PEPs, reiterating the requirements set out in the MLRs that firms adopt a risk-based approach to the identification of PEPs, who should then be subjected to enhanced due diligence. The guidance recognises that it's unlikely that a large number of UK customers would meet the definition of a PEP, and sets out that UK PEPs should be treated as lower risk than PEPs from jurisdictions with high levels of corruption. In January of this year, the Office for Professional Body Anti-Money Laundering Supervision, or OPBAS, was set up by the government as a new regulator to oversee the work of the professional body AML supervisors and to ensure consistent standards of AML supervision in the legal and accountancy sectors. OPBAS, which sits within the FCA, does not directly supervise legal and accountancy firms, but is intended to facilitate collaboration and information sharing between their professional bodies. OPBAS also has an enforcement role, with powers of public censure and powers to recommend the removal of a professional body from the list of supervisory authorities under the MLRs. The FCA's AML report set out the findings of its systematic AML programme, which is a programme of regular, thorough scrutiny of 14 major retail and investment banks operating in the UK, plus a number of strategically important overseas operations. The FCA set out a number of weaknesses identified over the past year, including client assessments, which only considered a limited number of factors, failure to record the justification for decisions taken, and weaknesses in firms' anti-bribery and corruption framework. In its inspection of other high-risk firms falling outside of the systematic AML programme, the FCA found what it described as serious deficiencies in some firms, mostly smaller overseas banks. These included poor identification of PEPs, ineffective application of enhanced due diligence to those PEPs who were identified, and poor levels of training among customer-facing staff. The FCA's reviews of these firms have led to the commencement of 4 enforcement investigations and 7 Section 166 skilled persons reviews. Turning to the FCA's enforcement record more generally, over the past year, 269 final notices were issued and 16 financial penalties imposed, totalling £69.9 million. While these figures are dwarfed by the financial penalties imposed in 2015-16, this comparison is somewhat distorted by the exceptionally heavy fines imposed in relation to LIBOR and foreign exchange manipulation during that year. The number of cases opened during the year has certainly increased when compared to the figure from 2015-16. The number of cases closed within the year has also appreciably increased. This is consistent with the FCA's new enforcement approach of opening formal investigations earlier, conducting early-stage interviews, and keeping cases under constant review, discontinuing those where the threshold for enforcement is not met. Beyond the imposition of financial penalties, consumer redress continues to be prioritised, with Vanquis Bank paying £168.8 million in compensation to customers for its failure to disclose the full price of one of its add-on products, and Capita Financial Managers Limited agreeing to pay £66 million to customers who suffered detriment as a consequence of its unregulated investment scheme. The case of Capita provides a particularly good illustration of the FCA's focus on consumer outcomes, as Capita avoided a financial penalty due to the fact that the imposition of one would have rendered it incapable of compensating the fund's investors. The expansion of the FCA's jurisdiction over the retail sector continues, with the publication of a list of unauthorised binary options providers in January 2018, when binary options became a regulated product, and the imposition of restrictions such as leverage limits and negative balance protection on contracts for difference. In the coming year, the FCA will be evaluating the effectiveness of those interventions. The first enforcement cases brought under the senior managers regime are now beginning to come through the pipeline. Barclays CEO Jess Staley was fined £642,000 for interference in an internal whistleblowing investigation, and we understand that a number of other cases are currently under investigation. The FCA has indicated that its culture and governance priorities for the coming year will include finalising rules to extend the senior managers and certification regimes across the financial services sector at the end of next year, the improvement and extension of the public register of firms and individuals, and a focus on firms' remuneration arrangements. In wholesale markets, the FCA will be looking over the coming year at reviewing money laundering in capital markets, monitoring firms' compliance with new conflicts of interest requirements and with FCA rules on IPOs. The final rules and approach to industry codes of conduct for unregulated markets will also be published. More generally, in relation to activity which falls outside of the so-called regulatory perimeter, i.e. where activity is unregulated, the FCA still has certain powers to act in some circumstances, the manipulation of LIBOR being a good example. While the activity itself was unregulated, the FCA was nonetheless able to take action against approved individuals who had engaged in it. Andrew Bailey has stated that the FCA is more likely to take such action where the unregulated activity could potentially undermine confidence in the UK financial system or have an impact on a regulated activity. Where they decide that they cannot or will not act, they will publicly explain why and raise the matter with other bodies or regulators or with the government. We've seen this approach in action over the past year in relation to the FCA investigation into alleged mistreatment of small business customers at the global restructuring group of RBS, in which the FCA, following a number of appearances by Andrew Bailey before the Treasury Select Committee, published in July an account of its reasons for concluding that no enforcement action should be taken. And finally, no forecast would be complete without a reference to Brexit, and the FCA's business plan for the coming year is no exception, setting out that it will continue to provide support and technical assistance to the government in its negotiations with the EU and with other countries where the government seeks a free trade deal. This includes advising the Treasury on potential cooperation arrangements and how the UK's future relationship with the EU may affect the financial services sector. Andrew Bailey has also indicated that it's likely that an EU transition or implementation period will delay the planned review of the FCA handbook.